Hi, everyone. Thank you for having me back. I was here with the last conference and really appreciated the opportunity to talk to so many of you who are on the front line in the elder, no, I'm not going to call it a battle, but in the frontier of paving the way in helping elders. I became an elder law attorney because I have an abiding interest in the issues of the elderly. I was not privileged to have parents who became very, very old, but I did have lots of aunts and uncles. And that's just have left with me feeling that we need to take care of those. I'm also a baby boomer. And so, you know, it's coming. What they call the silver surge or the silver wave is coming, meaning gray hair. And under here, there's some gray hair. I've got to go to the hairdresser next week and get it colored again. But anyway, I'm going to talk about what caregivers should know about elder law. First off, what is elder law? And it's sort of a new term. I've never heard of it when I graduated from law school about 1990, and I was a retread. That means I stayed home for a long time. I graduated, and I already told you I'm a baby boomer. I graduated from law school when I was 40. Well, actually, 39. Don't want to push it. And I was sworn into the bar the week I turned 40. And I've been a lawyer for 21 years. You get that. So what is elder law? So when I graduated from law school, there was no such thing. We never heard of that term. And as I went through, I became an estates and probate attorney, which does basically estate planning. And I'm going to be talking about estate planning. But the estate planning is planning to die. And it's mostly focused on taxes, or at least it used to be. It is focused also in making sure that you have your assets go where you intended them to go. You might not have children. You might not want it to go to your children, even if you do. So where do your assets go when you die, and how do you avoid the hassles and all of that of state administration after you pass away? And maybe you don't care, but maybe the family you're leaving it to would appreciate that. But that's a personal thing. Anyway, so I guess in about the mid-1990s, we started hearing a lot about some group of folks who were on a national scene that were had put together an organization called the National Academy of Elder Law Attorneys. And again, we were started, well, what is this? It's basically all the law that has to do with elders. I mean, what do elders care about? In testing to become an elder law attorney, I had to learn all about even employment discrimination against people who are older, housing issues, and all that kind of thing. Now, that's not what I do on a day in and day out basis. I do mostly planning for long-term care and estate planning. We do a lot of conservatorships and all. So, but those are all of those kind of things. That's what an elder law attorney sort of focuses on. Doesn't mean that we can't do estate planning for everybody. Of course we can. But that's what we focus on. And as time has gone by, I have done more and more focusing. So what should caregivers know about elder law now that you know it's sort of this whole great big body of law and different areas? And I have no idea. How do I get do I use this thing? What do I do? Push on this? Okay. All right, so elder law covers care issues, legal issues, financial issues, and elder abuse issues. Care issues, you guys are hearing a lot about that. I'm not going to talk about that today, but do know that more and more attorneys are looking at the care issues, and it's not just about the legal and financial. You really need to link those together with the care issues. And so a good elder law attorney is going to do that. They're not just looking at the legal issues. Financial issues are what most people come to me about. How do I pay for long-term care? How do I, provide that things? So that is intricately connected to the legal issues, and elder abuse issues. Those we get involved in, and because we have to, because they happen out there. Estate planning is where I began in my career, and that's what most of people think that an attorney is going to do. And it's basically, it's planning an estate for when you die. It involves avoiding probate if you can, minimizing taxes, making assets go where you want them to go, hopefully avoiding the challenges in the family that is not a good family, they're going to fight, and all of those kind of things. So how do we set it up to accomplish all of the person's goals in an estate plan? Sometimes we use wills, sometimes we use trusts. California is a very trust-friendly state. By that I mean that we have a body of law that is well developed, that runs trusts or provides for trusts. If you don't put the instructions in your document yourself, then California law provides that. We also have a large incentive to use trusts in California because probate is not terribly easy or friendly or inexpensive in California. Some states don't do too many trusts. When I talk about trusts and estates planning, mostly we're talking about those trusts that you've probably heard out there about, and you might go to sometimes seminars on a living trust seminar. A living trust is merely a trust that you create while you're living, but it's come to represent a certain kind of trust, and it's a trust that's revocable. A revocable trust is a trust that you create and you put down the information about what's supposed to happen when you die. You stay in charge of it, and you can change the terms of it at any time, as long as you're competent. And so sometimes people ask me, well, how often should I redo my trust? And I'll tell you, I think you should get it out and read it at least every 3 years, take it to your attorney every 5 years, and maybe replace it every 10 years. Because your circumstances change, your family, your legal issues. Sometimes the laws change. Well, the laws always are changing. Maybe your tax situation changes. So if I have a trust that comes into me and it's more than 10 years old, almost all the time we're going to replace it with a new trust. I compare creating a new trust in that situation like you bought a new property, bought a house, and you've been living there for a while, and it's gotten quite, it's not what you need anymore, and so you tear down the house and you build a new house right where it was. If you amend a trust, that's like adding on the extra bedroom. So if you replace a trust, it's generally we use the same name of the trust, we just amend and restate it, and that's creating a new trust in place of the old one without revoking the old one. It's just replacing all the language. So a living trust is a trust that you create while you're living and that you maintain complete control of, and that is revocable while you're living. A living trust, not that we would call it that, could also be an irrevocable trust. Again, while you're living, you create it. An irrevocable trust might be created, say, for your grandchildren, so that you're putting money in for their education. Or you might create it for the child that has some special needs, developmentally disabled or has drug problems or mental illness issues, and you want to protect the inheritance for them, and you want to set it up while you're living rather than upon your death. You could set up an irrevocable trust.